unless you give the landlord good cause to not continually give you a new lease, you could just be there forever. The landlord really loses a lot of control in this scenario.
Yeah, they do.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Welcome back to The Weekly Friedman, your source for the most essential information in the default industry. Today, I'm joined by Friedman Bartolo attorney Rick Tracy. Rick, how's it going?
Very good, thank you.
And we're going to be jumping into New York's good cause eviction law. This law was passed back in April of 2024, and we're going to be checking in to see how this is impacting post-foreclosure evictions. So, Rick, just to jump right in, right? Do you want to just remind the audience what this law means? Like, what did it do?
Yeah, so like we said when I last was here in the Weekly Friedman, how tenants are a very big political consideration in New York State, especially in New York City. And so they passed this law that essentially gives a perpetual lease to anyone who is renting in New York City and any other cities in New York that want to voluntarily adapt the structure. So if you are a renter in New York City, unless you are doing something that is problematic that would give good cause to evict, the landlord has to renew your lease continually. And they've also added certain other requirements, like if you file a petition for eviction in housing court, you have to include a certain notice with it that says, here's why you're being evicted, and other requirements that go with it.
It's kind of crazy. I mean, basically we're saying, unless you give the landlord good cause to not continually give you a new lease, you could just be there forever. The landlord really loses a lot of control in this scenario.
Yeah, they do. Although New Jersey already has that policy, but it's also coupled with a much more quick and effective eviction system. So you are actually able to effectively use good cause to evict more quickly and cheaply.
Okay. So how does this law play out in a foreclosure proceeding? Or how should it play out, and how is it playing out?
Yeah, so interestingly, our interpretation of this law is that by its own definitions, it does not apply to the post-foreclosure context. However, the judges, because post-foreclosure holdovers are really only like 1% of the cases they deal with, they sort of think in a broad brush. And my opinion is that when they first read the good cause eviction law, they weren't looking for the specifics over whether it would or not apply to our situation, because it is very rare. So a lot of judges at first impression do think that these requirements do apply to our cases in post-foreclosure eviction. In my opinion, they don't, and this is actually something that we're litigating right now.
I find it interesting because the law was clearly created to protect tenants, right? So why is it different if it's post-foreclosure? I understand logically why it is, but did the legislature just create a little carve out to make sure that if you were foreclosing, you didn't need to follow this law? Why would they do that?
Yeah, so the legislature, they put certain things that would make you interpret it that way, but didn't outright say this excludes post-foreclosure. So okay. in the definitional section, they do say a landlord is someone who is an owner entitled to receive rent. Well, in a post-foreclosure setting, especially against a former owner, we're not entitled to receive rent. And they also define a tenant as someone who's a lawful occupant, except for when no landlord-tenant exists, such as under Section 735. And Section 735 is the section that we use. However, opposing counsels have gone in and said, well, in that definitional section, they say that if you are entitled to receive rent, you're a landlord. And actually, we interpret your request to earn use and occupancy in an eviction, we interpret that as rent. So by asking for use and occupancy in an eviction, actually, you're saying that you're a landlord.
Right. No, because it's interesting, because you would be surprised if the legislature specifically made it so that if you're post-foreclosure, you get an added benefit. Just in knowing how New York operates, that would have been a surprising development to some extent. But I think it's somewhere in the middle, right? It's like there's a carve out there. It's not explicitly removed, but that's an interesting way of seeing it. As you said, right, judges are not necessarily imposing or permitting the carve out. They're putting everything together and saying the good cause eviction law fully applies to post-foreclosure. Is that right?
Yeah, so they have their first impression, and what we're trying to do is use whatever opportunity we have to litigate this and maybe set a new precedent, because it at least according to my research, this is a novel issue. There aren't many decisions that I can see where a judge was interpreting whether to apply this to a post-foreclosure situation. So we're making motions to amend to satisfy the judge, but also trying to force the issue to get a little bit of interpretation from the courts.
How do you envision it playing out? What do you think is going to happen?
I think, at least on maybe one of these challenges that we have pending right now, there is one in particular that I have in mind where opposing counsel is trying to do discovery based on one of the aspects of the good cause eviction law, which is that if you're a small landlord, you own under 10 doors, then you are accepted from this. And these small landlords have to prove and plead that. They're asking for discovery based on that. And so we're opposing, saying, hey, this doesn't apply to us whatsoever. So if maybe depending on how deep into it the judge gets, we might actually have a decision that gives us some interpretation over whether we have the exception or not.
Really interesting. When do you think is the earliest we would have some clarity?
I would say probably over the next couple of months. If not, we're going to continue to move in our client's best interest by reading the judge's interpretation and not going headlong into what we think is going to be a bad decision and set a bad precedent. So we're trying to play it by ear and do best practices.
Makes sense. Well, look, I think in the next couple of months, we should definitely check back in. I think this is an interesting one because, look, it's very tied to our industry, very tied to how our clients operate, but it also has broader implications where, evictions is one of those practice areas where it really can go pretty deep and can impact a lot of other property owners outside of just our current clientele. So I think this is a really cool and interesting topic that I appreciate you working us through.
Sure, of course.
Thanks for joining Rick, Tracy, and I on the Weekly Friedman, your source for the most essential information in the default industry. We appreciate you checking in and looking forward to seeing you next time.